Hi everyone. First of all, I hope you all having a good day. I'm here to discuss with you the evidence of crime. Let's start with that definition. It is a legal definition, is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. There are three forms of evidence in criminal investigation. Number one, physical evidence. It refers to a physical object used as evidence which is obtained through searches at the scene of the crime. There are two categories of physical evidence. Number one, associative evidence. These are pieces of evidence which link a person to a crime. The offender may leave clues at the scene such as weapon, tools, garment, fingerprints, or foot impression. Two, tracing evidence. These are evidence that may assist the investigator in locating the suspect. B, biological and transient evidence. A biological evidence, it refers to evidence that is commonly recovered in a crime scene. Transient evidence. It refers to evidence that by its very nature can be easily changed or lost. For instance, transient evidence include temperature, odor, blood in the rain, and some biological and physical phenomenon. C. Other specific kind of physical evidence. Paint, soil, tool mark, shoe print, and impressions. Videotape evidence, dental evidence, computer, and other electronic evidence. Soil. The organic natural materials such as rock, mineral, and decomposing plant. Paint, pigmented polymer that is applied and adheres to various surfaces. Shoe print and impression. Shoe print are created with material from the bottom of shoes and transferred to another surface. Videotape evidence. Videotape is potentially extreme, powerful form evidence. Dental evidence. Two primary kinds of dental evidence are dental identification and bite mark. In both instances, the fact that an individual has unique set of teeth in terms of form, arrangement, dental work, and bite marks, dental evidence, powerful form of criminal investigation or criminal evidence. 7. Computer and other electronic evidence. Computer, cellular phones, and personal digital assistant may provide a wealth of information regarding a communication. Number two, testimonial evidence, known as eyewitness testimony or communicative evidence. It is the witness product of interview and interrogation from which witness smell, hear, taste, and touch are being described through oral written testimony. There are three types of kind of testimonial evidence: ordinary witness, expert witness, and documentary evidence. Number one, ordinary witness. Any person who perceived the commission of a crime and testified before the court is just considered as an ordinary witness. Number two, expert witness. A person whose testimony concerning the investigation of crime is based on his training experience. Documentary evidence. It refers to writing including official records or content that could speak for themselves when read by the investigator in court. Lesson 2. Legal classification of evidence. Number one, ability to establish a fact and dispute of an evidence. There are two kinds of legal classification of evidence. Number one, direct evidence. It is that which prove the fact in dispute without the aid of any inference or presumption. Number two, circumstantial evidence or indirect evidence. The proof of fact or fact from which taken either singly or collectively the existence of a particular fact in dispute may be inferred as a necessary or probable consequences. The following requisite must be present before a circumstantial evidence will become sufficient or conviction. 1. There is more than one circumstances. 2. The fact from which the inference are derived are proven. 3. The combination of all the circumstances is such as to produce a conviction beyond reasonable doubt. B. Degree of value in establishing a disputed fact of an evidence. There are four types of degree of value in establishing disputed fact of an evidence. Prima facie evidence. This evidence suffices for the proof of particular fact until contracted by other evidence. Number two, conclusive evidence. This evidence is introvertible or one of each law does not allow to be contracted, or it is insurmountable evidence. Number three, corroborative evidence. This evidence is of different kind of character as that already given and tends to prove and same proposition. Number four, cumulative evidence. This evidence is of the same kind of character as that already given and tends to prove from same proposition. C, weight and acceptability of an evidence. There are two types of weight and acceptability of an evidence. Number one, primary or best evidence. This evidence afford the greatest certainty of the fact in question. Two, secondary or substitutionary evidence. This evidence is inferior to primary evidence and admissible only in the absence of the latter. D, nature of an evidence. There are five types of nature of an evidence. One, object evidence. This evidence is addressed to the sense of the court and capable of being exhibited to be examined or viewed by the court. This is also known as eutoptic evidence or real evidence. Number two, documentary evidence. This refers to evidence supplied by writing instrument or derived from conventional symbols and letter by which ideas are presented for material substances. Number three, testimonial evidence. This evidence is either verbal or oral. It is an evidence which consists of a narration or deposition by one who has observed or has a personal knowledge of that to which he is testifying. Number four, positive evidence. This evidence exists of the witness affirms that a fact did or did not occur. Number five, negative evidence. This evidence exists if the witness states that he did not see or know of the occurrence of a fact and there is a total disclaimer of personal knowledge. E, quality of an evidence. There are four types of quality of an evidence. Number one, relevant evidence. Evidence is relevant if it has a relation to the fact in issue as to induce belief and its existence or non-existence. Two, material evidence. This evidence tends to prove the fact in issue and it is determined by the rules of substantive law or the rules of the court. Number three, admissible evidence. This evidence is admissible if it is relevant to the issue and it is not excluded by the rules of court. And lastly, credible evidence. Evidence is credible if it is not only admissible evidence but also believable and used by the court in deciding cases. Lesson 3, collecting, marking, and tagging, and preserving evidence. Collecting physical evidence. All items were found in the crime scene should be collected. The collecting officer should not decide whether a certain item is relevant or irrelevant. Small pieces of evidence also must have to be given importance, thus collecting them necessary. Number one, blood. It is important evidence in homicide, assault, robberies, or other cases where it may be spilled. It categorized into a major group of A and B, or A, B, and O, depending on the condition of the stain on the receipt. There's a 6 collection of liquid blood. Letter A, use clean, disposable, or eyedropper for each sample collected. B, place the sample in a container avoiding airspace because air will cause the blood to dry. C, if the amount of blood is minimal, collection may best be made by placing the sample in a normal saline solution, 1 tablespoon salt in 1 part of distilled water. D, refrigerate sample in saline solution as soon as possible. E, do not mix areas where samples are collected. And lastly, F, above all, avoid contaminating the samples by reusing collection tools. And collection of dried blood. There's 3 types of collection of dried blood. A, on absorbent surfaces, bring in the entire object or cut out the stained area and bring to the laboratory. B, on non-absorbent surfaces, scrap up the sample and place in container. And lastly, C, if sample is scrapped from surface, also scrap a portion of surface where no blood is present and submit in a separate container of control in case some substances on the surface cause difficulty in test. And collection of wet blood on clothing. There's 4 types of collection of wet blood and clothing. A, do not fold the clothing as may destroy the stain pattern. B, do not package while the stain is still wet. And C, allow the clothing dry in a room before packaging. D, do not expose to sunlight or high temperature as they may destroy factor which will determine blood typing. And number 2 of collecting physical evidence, hair. Hair, this may be found anywhere in the crime scene. It is also often found in the clothing of the victim and suspect who have come into physical contact with each other. There's a 7 collection of hair. A. Take a sample of head hair from the top and black and each side of head. B. Take by combing, pulling, or cutting close to it. C. Take at least a dozen of hair from each location. D. Each of the samples should be collected in separate container and properly labeled. E. Identify the hair carefully as to exact location found. And F. Do not mix hair found in several locations. G. Place the hair in folded paper and put it in an envelope in glass vial and seal. And lastly, H. Do not tape the hair to an object as it will alter hair and destroy any debris adhering to it. And number 3, fingernail scraping. Fingernail scraping. In case where physical contact has been made, fingernail scraping should be obtained. Rape cases or assault cases are good example of cases where fingernail scraping may be important. There's a collection of fingernail. There's a 4 collection of fingernail. Brad. A. Clean each fingernail with a clean fingernail file. B. Place the scraping form each fingernail on already labeled paper with notation of which finger it come from. C. Place the scraping form from each finger in a separate envelope or glass vial. D. Fingernail scraping should be obtained from both victim and suspect. And lastly, if the subject's hand is contaminated with blood, note this on the container. And number 4, fiber. Number 4 of collecting physical evidence, fiber. It is excellent tracing evidence when clothing contamination takes place. This also important evidence in robbery and hit and run cases. There's are 4 types of collection of fiber. Letter A, treat and package fiber in the same manner as hair. B, be extremely careful not to cross-contaminate during the collection process. C, collect the clothing which is source of fibers. And lastly, D, do not shape the item as they may dislodge the fiber. And number 5 of collecting physical evidence, glass. Glass, it can be important evidence in robberies and hit and run cases. It may be found as a trace evidence in clothing and shoes. Glass is usually examined to determine if both of evidence sample and the known standard has the same physical properties and trace elements as impurities. Collection of glass. Collect from each broken glass at the crime scene. B. Package item individually in glass vials or envelopes. C. In hit and run cases, collect all broken glasses to ensure the possibility of physical match should fragment be found in suspect vehicle. And number 6 of collecting physical evidence, firearm. Firearm, bullet, shotgun shell, shotgun pellet, and wad, explosive residue, and gunpowder pattern can provide vital evidence and specific answer to the possible question in case. There's a collection of firearms. A firearm must be handled carefully not only as safety measure but to avoid disturbing any evidence they may provide. B. They must be proper marked for later identification. C. Never insert anything in the barrel as it may damage, then identifying the characteristic and dislodge material which may be inside the barrel. D. Unload but do not wipe or clean the weapon. F. When unloading, carefully record the location of unfired and misfired cartridges. G. Record the serial number description of the firearm. And H. Firearm with no serial number should be marked with essential on the receiver or the underside of the barrel. Never use X or none or other non-individual types of marking. Do not mark the weapon on any easily removable part such as stock or grip. Use discretion so as not to disfigure the weapon. Don't it in the collection of firearm evidence. Never submit a loaded gun to the laboratory unless it is delivered in a person. Never clean the bore, chamber, or cylinder before submitting a firearm, and never attempt to fire the gun before it examined in the laboratory. C. Never pick up the weapon by placing pencil or other object in the end of the barrel. D. Record the serial number, make, model, and caliber of the weapon, and mark it in some inconspicuous manner that does not detract from its value before sending it to the laboratory. Number 7 of collecting physical evidence. Bullet. It can provide information about the make and type of ammunition and weapon from each. The bullet was fired and whether or not it was fired from specific weapon, provided the weapon is available for test purposes. Collection of bullet. A. Handle the bullet as not to dislodge any extraneous materials or damage the marking. B. If a bullet is lodged in the wood or similar material, cut out the lesson and bring it to the laboratory. C. At autopsies, request the use of hands or rubber tip force to minimize the possibility of damage to the bullet. And D. Wrap each bullet separately in tissue in cotton to prevent damage and place in container. Number 8, and collecting physical evidence. Cartridge case. This can also provide vital information as to the type of weapon used, the type of ammunition, and whether not the case was fired in a specific weapon. If weapon is available for fire testing. Collection of cartridge cases. Handle cartridge cases so as not to add any scratches or mark. B. Wrap each one separately to prevent damage. C. Be sure to note specific location in which was found. And number 9, and lastly, number 9, in collecting physical evidence, seminal stain. It is often but not always found on clothing blankets, sheets. It is also a biological evidence, like blood. It must be collected properly, maintain it is integrity. Collection of seminal stain. Allow any stain to dry, air wrap, and paper and package evidence in paper bags. Do not use plastic bags. After sex offense cases, the victim should always be examined by a physician. C. Label all garments such as undershort, panties, or other exhibit and package each garment separately. D. If damp, allow fabric to dry completely before packaging. E. Handle fabric as little as possible. B. Marking a physical evidence. As evidence is collected, it is individually marked with the initial of the investigator. The marking tools depend upon the nature of the evidence. If it is hard objects such as metal, the initial are scrapped or engraved by the use of sharp-pointed steel called stylus. General rules in marking tools or object as physical evidence. Number 1, marking of firearms-related evidence. Never use X. 3, record any serial number if applicable and other distinctive mark. Mark the object without damage. 5, always mark the container in which the object is placed even if object it is itself already marked. 6, when tags are used, make a corresponding entry in the tag and attach it securely into the object. There are 5 types of marking of firearms-related evidence. Number 1, revolver, pistol, rifles. 4, firearms, empty shell and misfired cartridge. 5, bullets, slug, balls, pellets. Number 1, revolver. It must be marked separately on the barrel, from frame, butt, cylinder, and stock. Tape should also be put around the bore and the frame of the gun with signature of the investigator. 2, pistol. It must be marked on the barrel, frame, butt, magazine, and stock. Rifles. It should be marked on the barrel, frame, magazine, bolt, or slide. All magazine and accessories shall also be marked. Number 4, fired empty shell and misfired cartridge. It must be marked near the mouth of fired empty shell, not on the body. Number 5, bullets, slug, balls, or pellets. A bullet or slug can be marked on the ogive or nose as well as in the base, not on the body or bearing surfaces. Letter C of collecting physical evidence. Tagging evidence. All evidence which by their nature could not be marked on each surface, which as blood, hair, fiber, and the like, are properly stored in appropriate container. Letter D. Preserving physical evidence. Perishable materials should be preserved along the way or the preservation in order to reach the court in the same physical condition as when they're collected from crime scene. Number 1, preservation of tool mark. Whenever possible, submit the whole object containing tool mark to the laboratory instead of just removing the area containing the mark. Number 2, preserving controlled substances and medical preparation. Each sample of material recovered should be placed in a paper container which can be sealed and marked. Be sure to properly seal, as lost material, particularly in this case of marijuana, can leak and spill. Number 3, preservation of question documents. Under no circumstances should either the question documents or the exemplar be marked, defaced, or altered. No new folds should be made, nor should mark or notes be placed on such material. Personal marks for identification purposes should be made as small as possible and on the back of the other area of the documents where no handwriting and typewriting is present. Number 4, preservation of Latin fingerprint. The primary precaution in all cases is the prevention of adding fingerprints to evidence or destroying those already present. Three types of fingerprints that can be found in crime scene. Latin fingerprint, patent fingerprint, and plastic fingerprint. Latin fingerprint are made of the sweat and oil on the skin surfaces. This type of fingerprint is invisible to the naked eye and requires additional processing in order to be seen. A patent fingerprint can be made by blood, grease, ink, or dirt. This type of fingerprint is easily visible to human eye. Plastic fingerprint are three-dimensional impression and can be made by pressing your fingerprint and fresh paint, wax, soap, or tar. Like patent fingerprint, plastic fingerprint are easily seen by the human eye and do not require additional processing or visible purposes. Lesson 4. General rules and equipment in processing evidence. General rules and equipment in processing. There are four types of general rules in the collection and preservation of biological materials. Number 1, use protective gloves. Number 2, avoid coughing or sneezing on evidence or materials. Number 3, packaging of biological materials. And number 4, special precaution. Use protective gloves. If possible, avoid touching individual smears traces. Remember that gloves can entail a risk of contamination. And avoid coughing or sneezing the evidence or materials. And number 3, packaging of biological materials. Use paper packaging for all biological materials that are soiled with biological matter. Although plastic bags are useful in many cases, they cannot be recommended for routine use on account of residual moisture. Number 4, special precaution. Make an explicit note of a person from whom material has been collected is suspected of having an infectious disease. Materials of evidence and evidence packaging materials and sealing. There are four types of evidence packaging and marking and sealing. Number 1, acceptable packaging container depending on the type of evidence include paper bags, plastic, or clear plastic is preferred for drug cases like marijuana, ecstasy, or tablet. Boxes, sturdy cardboard, and manila envelopes, small glass vials, typically arson and liquid drugs. Metals can typically arson. Number 2, acceptable seals like tamper-proof evidence tape, reinforced packaging tape, heat seal, and number 3, information of each package should minimally include name of the agency, agency case number, item number, date, the investigator, and identifier. And number 4, additionally, packaging of evidence should include where the item was found, by whom, date and time that item is found, and description of item. And traditional methods of preserving or recording evidence. There are 5 types of traditional methods and 10 types of traditional methods of preserving or recording evidence. Number 1, photographs, audio or videotape, microfilm, photostat, Xerox, voice tracing, etc. And number 2, sketching. Sketching, if no one scientific apparatus to preserve evidence is available, then a rough drawing of the scene or object to be preserved is done. Number 3, observation and description. Description is done by putting into words the person or things to be preserved. Describing a things requires keen observation and a good power of attention, perception, intelligence, and experience. And number 4, mannequin method. A mannequin method in a miniature model of a scene or of a human body indicating marks of the various aspects of the things to be preserved. An anatomical model or statue may be used and injuries are indicated with their appropriate legend. 5, preservation in the minds of the witness. A person who perceives something relevant or proper adjudication of a case may be witness in a court if he has the power to transmit the other what he perceived. 7, developing and lifting fingerprints found at the crime scene. 8, gathering physical evidence. And 9, plastic cast, and 10 written statement of subjects or witnesses. What is portrait, oral, or spoken picture? It refers to a verbal accurate and pictures where description of the persons identified. Integrity of trace evidence. Protection of a trace evidence from loss or contamination is essential. What is principle of chain of custody? It is of paramount importance to any investigation. It must it is the unbroken sequence of events that is caused by an item of evidence from the item is found at the crime scene to the time it appears in the court. What does chain of custody do? The chain custody proves the integrity of piece of evidence. A paper trail is maintained so that the person who had charge of the evidence at any given time can be known quickly and summoned or testify during the trial as and if required a record of the chain of evidence must be maintained and established in the court. That's all. Thank you.